Good afternoon, everyone, and welcome to our 7th seminar and this fall series of the Sunoikisis's Digital Culture Heritage seminars. And today we are talking about ethical and legal considerations about digital culture heritage. And we have today three speakers to talk about this, and the first one will be our Gabriel Bodard from the Institute of Classical Studies that has been with us a few times before. And we have Andrea Wallace from the University of Exeter and Richard Nevell from Wikimedia UK and also University of Exeter. And we're going to have a very rich seminar today and hopefully a lot of discussion. For the people that are watching this live, feel free to ask questions anytime using the comments on YouTube. And now we are ready to start. And I think that Gabby, you are first.
Yeah, cool. Thank you, Valeria. I'm going to talk briefly in this session about issues around copyright and authorship credit and related issues, and how these are important in terms of academic publication, and especially so, I think, when it comes to publication of digital resources and digital materials. And this, I'll try to keep this relatively brief. This will lead into slightly more specific presentations about the Wikipedia and Wikimedia world, and about various ethical issues around cultural heritage and display of cultural heritage, respectively. If we jump straight into my slides, please, Valeria. Thank you. These are the four parts of today's presentation. I'm talking about copyright and authorship credit. So just as a brief preamble to this, I don't want to go into detail about the legal definition of copyright, but copyright is basically a relatively recent legal construct that's sort of only come into existence in the last few hundred years, recent in the sense of human endeavor and creation, and it's a law that gives the exclusive right to the right holder, usually the author or creator, but could be another right holder, the exclusive right to reproduce and exploit, and that specifically means to profit from their creative work. It's usually, this is differentiated from something that might just be very, something that might have taken a lot of time, sweat of brows, it's sometimes called, which doesn't automatically infer copyright. There has to be some creative work have gone into something to accrue copyright. Copyright generally has a limited time span with some exceptions. There's that time span differs in different domains, and it has shown a tendency to lengthen over the last 100 years or so. It used to be copyright was very, very limited to usually not much more than 20 years, but it's now quite often 100 years or more from the time of creation. Something can still be in copyright. But there are specific exceptions written into most copyright laws. These are things such as fair use, the allowance to use things that might otherwise be not allowed due to copyright for using them in an academic context, or in a context of reporting on or reviewing something, or in the context of parodying something, things that have to be protected and that have to be timely activities. So I mention all this as a preamble to put into context the concept of open licensing. Open licenses work because what they do is they enable you to waive some of the protections of copyright. So if I create and publish a piece of work, by definition, if I don't say anything in particular about the rights I want that to have, that is under full copyright protection, which means that nobody, unless they're doing it in one of these protected ways in academic or creative or parodying contexts, nobody else can use or redistribute or even transform a recognizable version of my original work, whether that's a painting, a story, an academic article, or a film, or anything like that. So open licenses allow me to waive some of that. They allow me to say, they usually allow me to say that anybody can redistribute my work regardless of the normal restrictions of copyright. That they usually say that they can only do that so long as they keep my name on it as author. So attribution remains required. And some licenses may or may not allow commercial use, so people may or may not be allowed to sell my work. They may or may not be allowed to take my work and use it in contexts that are then under more restrictive licenses than the one I put on it. Some licenses say you can use my work, but anything that you create from it has to also have this free license on it. And they may or may not allow transformative use at all. They may just say you can redistribute it, but only in this form that I've given you. You can't translate it into another language or perform a written text into an audiobook or anything like that. Most of these open licenses are not do not put the work into the public domain. So the work still has copyright. It is still my piece of work, but some of the rights have been waived. So the most common open license of this kind for creative works is the Creative Commons license set, and the Creative Commons licenses have all of the characteristics that I've just described. The default license, the basic and most liberal license, if you like, is the CC BY, the attribution license, which allows people to do anything they want with this work, to copy, distribute, display, perform, transform, and distribute derivative copies of this work, so long as they give credit to the author or the copyright holder in any form. There are then these other further restrictions that can be attached to this license for various reasons, such as share alike, which is the one that says that anything you create, any derivative work you've created, has to also be under this open license. The non-commercial restriction, which says you can copy and redistribute my work and any derivative works, but you can't sell them or make money from them. And the no derivative restriction, which says that you can't do most of these things. All you can do is redistribute it. You can copy it, redistribute it, but you can't make new versions of new works that contain it in another way. All of these things can further then be waived in special circumstances, in the same way that under normal copyright I have full copyright control over a piece of work. If someone comes to me and says, I would like to perform your story or make a film out of your story, they can buy those rights for me, or I can give them for free, and so forth. All of those things remain true if they're restricted by the Creative Commons license. But the interesting thing about the Commons licenses is that which they do enable you to do without having to ask permission. So they really allow this sort of massive reuse. I can use hundreds and hundreds of different pictures all in one database because they're all from different places and they're all under Creative Commons licenses. I don't have to do the prohibitive amount of work of contacting hundreds of individual rights holders and finding out whether they allow me to do so. The final kind of Creative Commons license is called CC0. This is the public domain license. This does waive all copyright in the license. This means I no longer have copyright on this. You can remix, reuse, redistribute, perform it, and you don't have to say where you got it from. You don't have to say that I was the original author. The images that have been distributed, and you'll find a link to them in the exercise section of this, for example, are photographs that were taken by Andrea, but we can reuse them without having to tell anyone that they were taken by her, because she released those under a CC0 license. Note, however, that that's the legal situation, but technically, in an academic context, if you were to submit those photographs or any other CC0 or public domain work and claim that they were your work, you would still be committing plagiarism. Just as if you put an essay written by a 19th century author in to turn it in as a piece of assessment, it would come up as plagiarism and you'd be kicked off your degree for it. That's you won't have broken any laws, but there's academic rules that are broken by that. So copyright and the rules of behaviour are two separate things. So these open licenses are useful in all sorts of contexts. They're useful to the user. Why would an author choose to open license their work? If it means that it might make it less likely for me to make money from my work, or I might lose control over my work in some context, why would I choose to put an open license on my work in this way? Well, there's various reasons for doing so. One is if I want people to reuse and remix my work. If I've produced some software or a data set or some other creative academic output that very specifically in a digital context, that part of the reason that I'm publishing this in the first place is because I want it to be part of an ecosystem of materials that are being used in this discipline and in other disciplines. I want people to reuse, and I don't want them to have to waste their time asking me for permission every time. I open license them. If you are in a category of people and your work is in a category of work where obscurity is a bigger enemy to your success than piracy, then you might open license it because this might get it seen by more people. Independent bands early in their career, they're not making money, not because they're terrible, but because no one's heard of them. And they're not going to lose money to piracy because no one's heard of them in the first place. Self-published authors will sometimes distribute works under Creative Commons licenses because, again, this gets them a little bit more exposure and which helps them to build a reputation which may lead to future career enhancement. If you want other people to build on and improve your work, you have to put it under an open license to allow them to make derivative copies of it. Right? This is the situation of, for example, Wikipedia, which we'll be hearing about shortly, where all the material in Wikipedia is under Creative Commons license precisely because the content is only valuable because someone else is going to come along and improve it later. And if you believe your work is a public good and that you shouldn't have an exclusive copyright on it for 70 years beyond your death, then you might want to put an open license on it for one reason. And this, I think, is where a lot of academic work comes in. And this comes back, for me, this comes back to the whole concept of open scholarship that we see going back all the way back to 18th century Germany, when the first free universities were established. And they were free in the sense not that they didn't charge registration fees, but that they were independent from the church and they were independent from government. So they were free. Free-thinking universities. They established the essential rules of scholarship that we recognise today, which are that pronouncements have to be supported by evidence, not just by the authority of the author. That evidence must be fully described and reproducible, and that previous scholarship must be cited and acknowledged. And this means that this led to this scholarly method, which that's outlined in this slide, which shows a pattern of two books published 50 years apart by two scholars that are only able to do this because of the concept of open scholarship, that you can base your work on the work of previous scholars, as all work is based on the work of many, many previous scholars, because it's, you can't just say, well, I've published on the question of Plato's myth of the cave, no one else can ever publish on that again because I've now got the copyright on that. Those sort of things, that's academically would be nonsense. This 50-year time cycle obviously is massively accelerated under digital scholarship, and we expect this sort of collaboration between people who don't need to have ever met to be able to take place over the case of months or a small number of years, rather than over massive numbers of decades. So that's my points about open licensing. I want to talk for a few minutes now about citation and attribution, and so for that, to summarize, I've talked about how copyright is a legal framework, and open licenses fit within that. Academic credit has a different set of rules, right? So you can commit plagiarism even if you're not breaching copyright for whatever reason. That's about giving credit. It's not about not breaking the law. So there are differences legally between who owns the copyright on a piece and who is the author and who has the right to be identified as the author of a piece. which, so someone can buy the copyright to some works that I created. They then become the copyright holder, but they don't become the author, right? I still remain the author of that work. If I write an article and I sell it to a journal, and the journal, usually for no money, the journal then holds the copyright on that article and the right to publish it, and I've lost all rights to it, except I still have the right to have my name attached to it, right? I never lose that. And there's also a difference between legal rights and moral rights and other legal niceties. But I want to focus on the academic practice. And the thing I want to talk about for just the next couple of minutes is the fact that the cover of the book, or the title page, and most importantly the bibliography on the CV of the scholar, will name the author of a particular piece, right? Or sometimes multiple authors. There may be an acknowledgements page, or the first footnote in an article may thank a list of other people for their help with some work, some of which may be fairly substantial. And there may also be a whole range of invisible and uncredited labour behind that is not acknowledged anywhere. And I want to sort of pick apart that, and especially in the digital context, the kind of collaborative work that is necessitated by this is often obscured if all you were to look at was the title page and who the author is in a library catalogue. This is an issue that is not new. We know, in particular in history, that the 4 articles famously from 1905 published by Albert Einstein, probably most of those should have been, morally, as we would say, co-authored with his wife, but they weren't. There's been a whole Twitter thread, Twitter hashtag about this in the last year or so. Thanks for the typing. The number of articles that say, I would also like to thank my wife for typing this up and for having lots of ideas and all this sort of thing. Well, why isn't she a co-author? This sort of issue is, people are very aware of this. So who gets credit for co-authoring my article? So an article I've primarily written, right? Who would I give a co-authorship to? And there's a bunch of people on here. I don't want to necessarily go through all of these, but if I have a professorial collaborator who I discussed this with and who edited a first draft of this, that's probably a co-author, right? A student assistant who I paid to edit my copy for me probably did as much work as that professorial collaborator, but probably doesn't get to be a co-author in the normal sense. Might get thanked by name, or because I paid them, maybe I won't feel the need to thank them by name. I'm not talking about me here. I'm talking about an imaginary person. I hope I'm less of a dick than this imaginary person I'm describing. Various other people in the process who made smaller or larger contributions to this may or may not get a co-authorship credit, and it depends on discipline as well. Of course, in classics, very few people get a co-authorship credit. In the hard sciences, there's very strict rules about who gets co-authorship credits, and a team of research assistants working on a project with you, there may well be 20 co-authors on an article. Who gets the copyright is another related question to this. That's basically, if you're named as the author, you're the copyright holder, right? Whereas or rather, not the copyright holder, but you're the legal author, and you may also be the copyright holder if you haven't given that away to a journal. You may be thanked in very effusive terms. I may say in my first footnote that you actually had most of the ideas, but if your title's not on the front page, you don't actually have any legal rights to the work. If you're not thanked on the front page, can you put on your CV that you did a lot of work and you were thanked in a footnote? Not really. Will you get credit from your university promotion panel for this sort of work? There's also then the question of scale. If I make one contribution to a project, say a massive project like Pleiades, one contribution is probably not going to get anything on in terms of promotion panel credit. But if I've made thousands of edits, maybe that's something I could put on my CV if people are willing to understand what's going on there. Is the nature of my contribution transparent? On a project that I worked on a few years ago, we did list on the project page, and this is the XML file here because I don't have the project page, all of the interns who worked on that project over a few years, and there were quite a lot of them, and we were very explicit about them. We didn't want anyone to go uncredited. None of these were co-authors, of course. In the Snapdragon project, which is another project I worked on, we also had this list of various placement students and volunteers who had worked on the project over the course of a couple of years. They were all listed on here, all of which is very nice. None of them get co-authorship credit on their CV, of course. Tools in classics like the papyrological editor will allow me to pull up on that a list of all my contributions. Each one of these is a very small contribution and wouldn't be worth all on my CV, but because I've made hundreds of such small contributions, I could potentially say to my promotion review panel that one of the things I've done is contributed in hundreds and hundreds of ways to this massive important resource in the field. Likewise, I could pull up a list of all the contributions I've ever made to Wikipedia. There's more complex questions there, but would I ever get any academic credit for that? Not impossible in some very limited circumstances, very unusual circumstances. The final point I want to make is that I have just, in a way, by putting up the previous two slides on there, I've just bragged that I do credit my interns, right? When we have interns working on a project for me, I get people working on the project for free. They don't get co-authorship credit, but they get named at least, right? I'm better than than that imaginary sort of dick professor in the previous slide. But we still do need to think about what does it mean when I say I credit my interns? Those two slides were the wrong way around. Sorry, I made a mistake there. When I say I credit my interns, did I also pay those interns? Who pays them? Did they get paid by anybody? If they didn't, how can they afford to work for free or for next to nothing in this sort of context? And the flip side of that question, who can't afford to be an unpaid intern? Who doesn't have the time to be an unpaid intern? And that's why I asked the question then, what demographics are we excluding from contribution, from credit, from ownership, from advancement, from citation, and from internships or collaborations by these models of working? And I think, yeah, that was my final slide. I want to leave that sort of open question, and I'll hand over to Richard.
Right, thank you very much. I think that feeds quite naturally into how Wikimedia works. So let's pull up the slides. So I thought we've covered some licensing issues, a lot of which is also replicated within Wikipedia. I thought it'd be useful to look at the structure of Wikipedia and how it works. To work out where the responsibility lies for what actually goes up there. So this is a very simplified summary. There's an organogram out there which is absolutely huge and wouldn't really have fitted on this slide in any way which people could actually read. But in essence, at the top is the Wikimedia Foundation. They're the non-profit in the US who do development, they keep the lights on and the website running. They do fundraising and they advocate for change to adopt open licenses and for organizations to be more transparent. And then there are Wikimedia affiliates. Those are organizations like Wikimedia UK, who very often receive funding from the Wikimedia Foundation. And our work is to identify areas within Wikipedia and its sister sites, look at the gaps and look at what can be improved. And we do this through mobilizing volunteers, training them, giving them skills to participate, and also working with cultural heritage institutions, whether that's libraries, museums, and universities. So giving their people, whether it's staff, volunteers, or students, the skills to engage with Wikipedia, partly as informed readers, but also as contributors to this vast public resource. And so the writers themselves, commonly referred to as editors, but it's not a formal position like you would have with the editor of a journal or book. Editor literally just means someone who has made a change to Wikipedia, whether that's fixing a typo or creating new pages, creating 100 new pages. Both of the people who've done that are editors. And fundamentally, they are the engine that drives Wikipedia. They are the people who write the 6 million articles in English, the 51 million articles across more than 300 languages. They are the people who create the content. And they're also the people who create the framework which underpins the content, deciding what is the kind of subject to be covered by an encyclopedia. They decide on policies like verifiability, which insists that content within Wikipedia needs to be sourced to something which is reliable and published by a third party, such as a journal or a newspaper article or a book, for example. And they're the ones who set the standards within the community and decide what goes in. Now, on the subject of copyright, Wikipedia has a sister website called Wikimedia Commons, which is a media database, really. It has something like 60 million files, mostly images, some videos, audio clips, and the occasional 3D model. It's a huge resource, all available for people to reuse as long as they give attribution and abide by Creative Commons licenses. But Wikimedia Commons also has to respect the various copyright laws of just about every country worldwide. So the guidance on Wikimedia Commons about how to take part and share content is very extensive indeed. Now, the Wikimedia community have made some decisions about what kind of stuff to include. So, for example, while the Wikimedia Foundation is a non-profit organisation and could therefore include content which is available under a Creative Commons non-commercial license, they decided that's not open enough. So they restrict themselves to licenses which require attribution, have a share-alike condition, but stuff which doesn't allow derivative works or doesn't allow commercial use doesn't appear on Wikipedia, simply because it's not open enough. And the community decided that if they're working on this project, which they want to basically summarize the whole of human knowledge, for it to be most useful, you need to remove some of those restrictions. And so it gives us a very reusable set of media, text, and information. So it ends up just about everywhere, especially online. Now, looking back to 2009, Wikipedia was 8 years old. The community was flourishing. It had hit the mainstream and was very well established and building a reputation at this stage. Now, the servers which host Wikipedia and Wikimedia Commons and all the sister sites are hosted in the US. So fundamentally, they absolutely must abide by US copyright laws, which gives us an interesting situation. In 2009, the National Portrait Gallery was digitizing their collection and putting some of this stuff online so that you could view it and you could get really up close with the images, zoom a long way in. Now, an awful lot of these images were in the public domain because the artist had died more than 100 years ago in many cases, and even longer. So a Wikipedia editor, who also contributes to Wikimedia Commons, came along and downloaded these high-resolution images from the National Portrait Gallery's website and uploaded them to Commons, marking them as being in the public domain. The National Gallery objected to this because they felt it threatened their income stream. Apparently, they earned around £300,000 a year from the rights to these images. They said that in the process of digitizing them, they had the right to reassert copyright on the principle of sweat of the brow. Now, that's a UK piece of legislation quirk. So the fact that the servers were hosted in the US meant that it wasn't as relevant. And especially since there was actually some debate about whether sweat of the brow applied in this situation. Now, the National Portrait Gallery essentially threatened legal action over this. They wanted the images to be taken down so it wasn't undermining their income stream. And I think, so legally, perhaps the person behind this didn't do anything wrong, but we have at Wikimedia an ethical responsibility to make sure we're not undermining cultural institutions. So if we're removing a source of income for an organization, I can certainly understand why that would concern them. Because whether it's the National Portrait Gallery or a small museum run by volunteers who might try and keep their museum free to visitors, but have a small stream of income from images, we have a responsibility to make sure that when we share information about them, we're enhancing the experience, not just for them, but for the visitors, the general public, and that we're not kind of sucking up all the water out of the soil so that they can't thrive as cultural heritage organizations. If we're doing that, it's ultimately self-defeating, because Wikipedia, its greatest strength comes from being able to reference scholarly publications, books, and stuff from museums and galleries and libraries and archives. And so if we're inadvertently undermining them through our work to try and share their stuff, then I think we're not really doing our best with that. And so this was a long time ago for Wikipedia, quite frankly, 10 years. And before there was really a concerted effort to engage with cultural heritage organizations. And now we work much more closely with them. So in the UK, we work with people like the Bodard Library, the National Library of Wales, the University of Edinburgh, and we're helping them share their stuff online under an open license. So you get credit for hosting the content originally and doing the curatorial work. And we're doing them in a way which gives them some agency in the process as well. And since then, the National Portrait Gallery has shifted towards using open licenses for low resolution images, so making some of their stuff much more open and available to the public. Now, Wikipedia strives to be neutral in its content. Now, this means that all the information within Wikipedia has to be referenced to verifiable sources. So the news reports I mentioned earlier, journals, and so on. And aiming for neutrality is a very good aspiration. How practical that is another matter. So it's not a matter of giving all viewpoints the same weight. So it goes by academic consensus, which is very useful. So for example, when it comes to global warming, Wikipedia will let you know that it's an anthropogenic cause, because that is what the scientific consensus is. It might mention as well that there are some fringe theories around this, denying that humans are involved in climate change and global warming, but it will frame it very much in a case of this is not the broad consensus, this is an unusual view. And so that works very well for some subjects. And the reason this whole verifiability has come about is so that you can trust Wikipedia's content, essentially. You can go back and track back where the information has come from. And so that you don't have to take it at face value, which is a really important aspect given it's a crowdsourced project. Literally anyone can come in and contribute, and it can be incredibly useful, but without being able to see where it comes from initially, it makes it much more difficult to be sure of that information. But in doing so, it does then replicate inherent biases within the source material and the community that writes this content. So, within Wikipedia, most of the contributors are male, and that reflects in the content they create. And if the source material itself doesn't treat a subject in full, then Wikipedia doesn't yet have the mechanisms to go beyond that and add extra information. There's in fact a policy saying that Wikipedia does not allow Wikipedia editors to come up with their own theories or ideas about a subject. It must have been published elsewhere first. And so, though it strives to neutrality, by default, it would tend to replicate the structures we see around us, especially in publications and online material. An important aspect of this is who contributes to Wikipedia. Most of the writers are male, and as a result, by far and away, most of biographies are about men as well. And even when you do get biographies about women, it's not uncommon to find them framed as by their relationship to, say, their husband, rather than starting off with their career. So these issues in the sources and in the structures around us get reflected within Wikipedia. And most of the people who contribute to Wikipedia are university educated. So that leads towards another kind of bias as well. People who can afford to go to university, essentially. And so you end up disenfranchising people from taking part in what is meant to be a participatory project for absolutely anyone, anyone who wants to share information. And so organisations like Wikimedia UK have taken proactive steps to redress this situation. Because if the default position is to just repeat the structures around us, you need to be conscious about these issues and try and work against them. So Wikimedia UK, we do lots of events to decrease the gender gap, both in terms of editors and the biographies about people. And as well, make sure that women's work is cited within Wikipedia, which is an area which isn't as well studied, but you can almost guarantee that by and large, Wikipedia articles rely on publications written by men. So when it comes to cultural heritage, we then have the issue that it is skewed towards institutions which already have a digital presence. It's not surprising, really. If your stuff is already under an open license and online, then it's very likely to then be repurposed and appear in Wikipedia as well. And the benefits of that is that it will reach a huge audience. Wikipedia gets 20 billion page views every month. Every cultural heritage institution should really want to plan how to take part in that. A bit like they might have a social media strategy for sharing stuff through Twitter and Facebook so people engage with their content. And it creates interest in people who could never reach the museum, but also people who might not have heard the museum, but are actually physically able to visit it and get more out of it. But as a result, it then does tend to privilege the large museums who have staff who can put time into this, who have teams who can deal with copyright issues, who can have discussions around relicensing their digital assets. And so it's still important to engage with those smaller organizations because they very often have some of the more unique collections. And stuff which already exists on the margins, you want to make sure they don't drop off the page altogether. A bit like with undermining income streams, you don't want to swamp the internet with stuff from one particular museum or one particular culture, because that reduces the overall quality of what's online by drowning out the variety. Now, Wikipedia is a crowdsourced project, anyone can take part, and in the last month, more than 400,000 people made an edit to Wikipedia. Once you start looking at who's more active, the funnel has fairly steep sides, it has to be said. If we're thinking about just 5 edits, so someone who's could be fixing 5 typos, adding a sentence to 5 different articles, or creating 5 new pages on Wikipedia, that's a much smaller group, 70,000 people. That's still about the size of a large town, but already you're funneling it down quite a bit. And if you're talking about people who edit Wikipedia on a daily basis, that shrinks even more. So I don't have figures to hand for that, but we're talking more around 5 to 10,000 people who are really very, very active with this. Now, because Wikipedia relies on third-party verifiable sources, it speaks towards certain types of publication. There's a PhD student, Jeanette Gimmerstam, from the University of Leicester, who has used her PhD to look at how Wikipedia represents rock art sites and who's involved in curating and sharing this knowledge. And it's a really interesting point, because she says that a lot of the people who are involved in making these discoveries initially are actually members of the public. Now, when it comes to Wikipedia, you can't cite members of the public in these becoming from what it has decided is a reliable source. Wikipedia isn't geared towards, say, using oral history. And you can't go to Wikipedia and say, I have found this particular piece of rock art, because what the community will do is say, how can we take you at your word? We need something to back this up. And so, though it's very much a participatory project, in terms of crowdsourcing, it's really focuses on stuff produced through formal research rather than more crowdsourced kind of projects you see elsewhere. And when it comes to ethical issues around sharing content, Wikipedia has done very well in some areas. So when it comes to copyright, it's very strict about that. When it comes to plagiarism as well, even if stuff is coming from a public domain source, it demands attribution. It does not permit plagiarism at all. It's got policies around biographies of living people and medical topics, which insist a really high level of sourcing, because these can have real world repercussions. But when it comes to digital cultural heritage, it's much less well formed. So this is reflected in the content of Wikipedia. The pages on this particular subject are really short, which shows that there's not much engagement from professionals who deal with digital cultural heritage and documenting it through Wikipedia. And Wikipedians themselves aren't necessarily experts in this area. So I think there's a theoretical gap here. So there's been no discussion about, say, portrayals of human remains on Wikipedia. When is it appropriate to do that? When is it not appropriate? How do you handle that kind of thing? And so there needs to be more development in this area, I think. And Wikipedia has, because of its power and reach, probably a lot more considerations to do around the ethical issues with engagement. It does a good job of sticking to copyrights, but when it comes to the ethical stuff, it's got a bit of work to do. Not necessarily doing stuff that's wrong at the moment, but I think it needs to have a more theoretical basis and ensure that editors are working from a common playbook, really. And so that's it from me when it comes to Wikimedia. So I will hand over to Andrea.
You should unmute yourself, Andrea.
Awesome. Is that working? Can you hear me?
Yes, working now.
Okay, thank you. So yeah, thank you for both of those excellent presentations, really delving into some of the ethical issues when we're thinking about copyright as being an appropriate regime to apply, and especially in the context of how it's regulated and the type of content. I want to then kind of flip that on its head, and I want to talk about use and reuse of cultural heritage data in a post-colonial context. So we can go to the slides, if that's okay. Great. So, oops, let me see how I advance. Yeah, awesome. Open data. When we start to think about open access and what that means, I want to kind of reframe this around an issue that's not necessarily new, but that is gaining momentum because of its digital aspects. And that's the debate around restitution, and specifically how intellectual property concerns are crucial to repatriation policies, despite the fact that they're really not involved in the debate right now. So as a bit of a copyright refresher to build on what's been discussed previously, I want to kind of frame it in terms of what's relevant for the discussion to follow. But to be fair, I teach an entire module on copyright and artwork, so this is a very cursory glance. So copyright protects original works of authorship. And the term of protection is the life of the author plus 70 years after death. In general, there are exceptions to that in various areas of the world. So if an author dies today, their works will then pass into the public domain around 2090. And copyright is accompanied by moral rights, such as the right of attribution and the right of integrity. But the key question kind of in this area is whether or not a reproduction is sufficiently original to attract a new copyright. So if you think back to the example that Richard used with the National Portrait Gallery, the underlying works are in the public domain. And then the process of taking that photograph, we have to question whether or not there is anything about that reproduction process that creates a new work that is sufficiently original. So that new photograph, whether or not it should be protected by a copyright, or whether it actually is in the public domain, so a copyright claim could be inappropriate. But something else to keep in mind is that copyright is territorial. It's gradually been harmonized over decades and even centuries by international conventions. But in the EU, in terms of originality, we kind of phrase this as the author's own intellectual creation, but with each member state having its own national phrasing. So the idea is that in application, it means the same thing. But in the UK, we refer to the threshold of originality as skill, labor, and or judgment. In theory, there's really no difference between these standards. In practice, that's not always the case, and that's why lawyers are employed. So if we start to think about how this applies to kind of the changing landscape around restitution, governments across the EU and elsewhere have been revisiting repatriation policies and evaluating where national institutions should stand in returning colonial-era objects that were collected from formerly occupied countries. And at the moment, this discussion is heavily focused around Africa. And while it may seem that IP is tangential to this discussion, it's just as important to consider alongside any changes in the law that are required to enable material restitution. But one thing that I want to start by doing is kind of acknowledging where we sit within this debate. And this is also some important framing that I'll elaborate on in a second. So I'm making some certain assumptions about this group and the people who are watching this video, but considering that we're sitting in the UK, this also applies via our location in the history of the empire and colonization. So maybe you have seen this image and this specific image before. So it's from a tweet that went viral a couple of months ago. And in the background, we have a painting by John Trumbull that depicts the signing of the Declaration of Independence by the American forefathers. All of these people are settler, colonizer, landowners, and the painting itself is now displayed in the US Capitol on stolen native lands. And those red dots signal people who were enslavers. So they're people who financially and personally benefited from the exploitation of enslaved people. And the treatment of this image both obstructs our perception and exposes the underlying history of this constructed moment. And it calls on us to critically examine the legal and social systems that we have inherited, who they benefit, and to challenge their broad application as the world becomes increasingly globalized. So I just want to take a minute to highlight a seminal article that's in the reading. It's Eve Tuck and Kei-Wen Yang, and it's called Decolonization is Not a Metaphor. And the authors begin by reinforcing the notion that any decolonization discussion is highly contextual. But in this paper, they examine decolonization in settler colonialism. So they argue that decolonization brings about the repatriation of indigenous land and life, and that it is not a metaphor for things that we want to do to improve our societies and our universities. But it obviously translates, to other countries' histories of colonization through empire and forced occupation. And in fact, the authors criticize, the ease with which the language of decolonization has been superficially adopted into education and other social sciences, supplanting proper ways of talking about social justice, critical methodologies, or approaches that de-center settler perspectives. And they go on to argue that when metaphor invades colonization, it kills the very possibility of decolonization. It recenters whiteness, it resettles theory, and it extends innocence to the settler. And so it entertains a settler future and results in yet another form of settler appropriation. So what Tuck and Yang reveal in their paper throughout the discussion is this importance of terminology. And it's also discussed in an article by Pue Cairns, which is also in the reading. But it's kind of the context in terms of how we should be thinking about decolonization and what it actually means. So as we reflect on the systemic effects of colonization, should we be asking, what do we mean when we use the term decolonization, and especially who is we? Given Yuck and Tang's focus on how decolonization must be tied to indigenous land and life, are there areas where decolonization cannot occur? So, for example, in the United Kingdom, and who may be able to decolonize a given subject area and so on. So for example, are we as colonizers with the history of colonization practically able to decolonize? Because thinking about these things challenges us to consider words that might be more appropriate to bring specificity to the underlying act that reflects the necessary nuanced approach. So for example, consider the differences between decolonization and anti-imperialism, anti-colonial or anti-racism and diversity, sovereignty, anti-homogeny, anti-sexism, inclusivity, accessibility, anti-ableism, anti-capitalism, and so on. Because decolonization is often used as an umbrella term for any of these interventions that are rooted in disrupting the effects of centuries of white male patriarchy and Western oppression. And I do think that there's an argument here to be made around decolonizing certain collections or museums, considering that under Tuck and Yang's argument, restitution has to be tied to the repatriation of stolen objects and to communities of origin. But at the same time, there are ways that we can bring these interventions back into spaces, and so that the treatment of objects that remain in situ, for example, in areas like the United Kingdom, where we can start to think about the process of indigenizing the practices of collection management according to that relevant community. Okay, so now I would like to kind of discuss copyright and its crucial dynamic here. So the legal systems that determine whether and under what circumstances copyrights arise in both material and digital culture are products of colonial histories, starting with the 1710 Statute of Anne, which was the first modern copyright act, and leading to contemporary copyright law. So this is why, it's arguably impossible for us to discuss decolonizing copyright within the terms that Tuck and Yang discuss, because copyright is a product of the colonizers. And through various international conventions, it's been transplanted into other national laws worldwide and harmonized according to Western values. However, we can acknowledge that the boundaries of when copyright and open access might be appropriate and when it might not. And this is what I kind of want to focus on. So it's what Tuck and Yang called settler colonial structuring. And that's a structuring of copyright, open access, and the management of digital cultural heritage. Because it's important to kind of frame decolonization in this area as restitution rather than anything else. So I think, the focus here will be on sustained colonial structures like the law and how to change them so that they no longer prohibit or impede the restitution of cultural heritage. Because this kind of idea around law as a barrier includes the systems regulating the underlying objects. And these are the systems that sustain ownership and control over the work's digital life. So these laws are often held up as barriers to restitution, but excuses that the law doesn't permit restitution of looted materials are really false claims to innocence, because these laws can be changed. They were inherited and they go through revision processes on a regular basis. We can certainly revise them to enable restitution of objects according to new laws. So if this sounds a bit abstract, let's kind of apply this to an example to make it less so. Open GLAM, which is the term for galleries, libraries, archives, and museums, has been a movement that's championed the digitization and release of public domain data for public reuse. But instances like these, which are framed as open by the institution that releases the data, are not actually open if they prohibit commercial reuse. And that's something that Richard touched on when he was talking about what type of content is appropriate for Wikimedia. So if you see the image that's in the picture there, that's actually a print by William Hogarth, and it's from his series A Rake's Progress. And so back in the 1730s, Hogarth played a crucial role in lobbying for the 1735 Engravings Act, which extended copyright protection to engravings that were designed and engraved by the same artist. And originally, this only lasted for 14 years after publication. So Hogarth's series passed into the public domain 270 years ago, but the public's ability to access and use this copy right here is restricted by the museum's copyright claim. And while we might enjoy a certain irony in the museum's perpetual copyright claim to Hogarth's reproductions in the very country where he helped formalize the law, this changes when we start to think about heritage from other communities that have suffered from the effects of empire and colonization. And in fact, there are various digital versions of Ho'ohaka Nanaya online, all of which are marked copyright trustees of the British Museum. And when you examine the rhetoric and the narrative around Ho'ohaka Nanaya, it seems unfit for a moai described by the descendants as a Rapa Nui soul. So the moai is one of many works held by the museum that have been requested by descendant communities dispossessed of their culture during colonization. But online and on-site, exhibitions fail to acknowledge this, and instead they present the moai as a gift from Queen Victoria. So accordingly, a combination of legal measures are used to justify the possession and exploitation of Ho'ohaka Nanaya, from the bequest notice in the gallery to the copyright notices online. But it's not clear how long this status quo will continue. And so in November of 2017, French President Emmanuel Macron commissioned a report on the potential of restitution of African cultural heritage. And 1 year later, scholars Felwine Sarr and Benedict Savoy published an extensive report in French and English on France's role. And it made recommendations for how restitution might proceed, which really caused other governments and institutions to re-examine their own practices. So this is a screenshot of the report itself, which you can download online. The primary purpose of it is, to lay out the history and responsibility of France to exploited African cultures and the challenges that underlie physical restitution, its administrative processes, and reparations. It's 250 pages, and I strongly recommend reading it if you're interested in engaging in some of these conversations. But there's a short section on the sharing of digital content on pages 67 and 68, and this is in the English version. So for works already digitized, the report recommends a radical practice of sharing, including how one rethinks the politage of image rights use, and promotes the creation of a single open access portal to documentation of African cultural heritage and associated materials held in collections. For works not digitized, the report recommends systematic digitization following a dialogue between institutions and the parties involved. So I want to take these recommendations and consider them in context, beginning with a radical practice of sharing. So as a recommendation, we should all want this, because the state of open and what that even means is often interpreted differently from institution to institution. But the underlying issue here is that, if adopted by the French government, it's going to set a double standard of imposing open and free access to digital cultural heritage collections of African heritage, while similar obligations are not expected of French national institutions. So this is actually a Google sheet of an OpenGlam survey that I manage with Douglas McCarthy of Europeana. And we collect different instances of open access data made available, whether it's on a collections basis, so a small bit of data, or whether the institution has adopted it, as a matter of policy. And at the moment, only 15 institutions in France make eligible data available for commercial reuse. And 9 have adopted open access policies for all data, rather than on that collections by collections basis. But of course, you still need to dig a bit deeper to see kind of what type of data is made available and what quality to get a more accurate picture. So this radical practice of sharing is not yet imposed on French institutions. And considering that intellectual property is a Western construct that carries its own colonial bias, it follows that the public domain and open access are components of this colonial thinking. But we should also look closer at the politics of image rights use. So one of the museums the report focuses on is the Musée de Quai in Paris, which holds 70,000 sub-Saharan African treasures, representing about 2/3 of the African objects held in France. So according to the museum's digital collection and exhibition portal, it hosts 1,063,313 objects of digital cultural heritage. And the museum claims copyright in all of it. So the politics that are embedded in this copyright secure to the institution the right to benefit economically from the object's possession and from the exploitation of its reproduction. And the claim to intellectual property carries the ability to exclude others from accessing the digital collection's embodied knowledge, and it fortifies the effects of colonization by rewarding the rights holder with control and access, or control over access and reuse. But the report, doesn't advocate emptying French museums of these collections. It starts by identifying a work of, or a group of works that are fit for restitution, like this Benin bronze. And, it highlights the many ways that African material cultural heritage has been exposed to a system of appropriation and alienation as a result of colonization. But it doesn't extend this system to considerations around African digital cultural heritage, because the impact that IP extends is to control how the work has been documented and cataloged, how it historically has been exhibited, as well as contemporary forms of exhibition, how it has been merchandised through postcards, and who has economically benefited from its commercialization, how it has been redocumented under new technologies over the years, and authority, knowledge generation, and dissemination around the works, including about the descendant communities themselves. So due to copyright, digitization carries the ability to kind of symbolically appropriate and control the knowledge, the personhood, the objecthood embodied in the material work. And if the material object is returned while the digital materials remain in France, then the digital materials are going to be alienated from the material work and the communities who are seeking to reappropriate their own heritage. So then the report's recommendation about systematic digitization also means that material culture will be digitized in France and then trigger the application of French and EU intellectual property law. But we should really be questioning who is best placed to undertake this task and the system of values that will inform this answer, because digitization itself is not a neutral act. We should critically examine whose needs are served by systematic digitization and explore how maybe more nuanced systems serving the communities of origin might be established through collaborative work. So Andrew Prescott and Lorna Hughes have written a paper that argues for a slow digitization process, which involves paying the same attention to the processes of digitization as we pay to the objects themselves, instead of rapidly digitizing cultural heritage to make it available online. And indeed, in digitization, as well as presentation, access, and control, is a cultural and curatorial prerogative that should belong to the community of origin. It will impact how heritage is represented, preserved, and remembered. And legally, the reality remains that works like the Benin bronzes were looted. So the choice to digitize and how should therefore be held by that community. But there's also concern that restitution might be conditioned upon digitization for preservation purposes. And we should accept that some of the works, of course, may be lost, but that this need to preserve the work is rooted in Western practices around collections management and preservation. And so I really like this quote by Hamidi Bokwem, who's the director of the Museum of Black Civilizations. And he said, "The restitution of Africa's stolen assets should not be dependent on us having space to display it. Those who stole our assets cannot dictate what we do with them. For example, if a community wants to restore their assets to the sacred forest from which they were taken, that is their right." And finally, all of us should probably, remember that the creation of a new digital resource should obviously sound familiar because we always want to go big and solve big problems. And in this case, digitization can enable wider African communities to access the culture during this transition and even after restitution. But restitution itself is already going to be a huge and complicated endeavor. So we should consider looking to existing models of digital heritage collections, cultural data aggregators, and online platforms that are designed by organizations that have successfully delivered similar portals. And this is one of the reasons why citizen-led initiatives like Wiki and GitHub are great platforms. While they're not without their own issues of authority and gatekeeping, as we just heard, they do enable communities to reclaim cultural narratives, especially in native languages. But we need institutions to play a role to help educate the wider public around sensitive treatment of heritage objects and to make sure that data sovereignty is respected. Ultimately, intellectual property is a Western construct, and it carries this colonial bias. So when we start to think about releasing things as open access, we then make that decision for the source communities. And there's a risk here of digitally imposing Western perspectives on how intellectual property should be exploited or not, and how access should be extended to this cultural heritage. So instead, we should probably start thinking about viewing certain materials as falling outside of intellectual property and digitization frameworks entirely. And so one of the other papers that's in the reading is this response that I wrote with my colleague Mathilde Pavis, and it was signed by 108 academics and practitioners from legal and GLAM sectors. And it's been published also as open access in the Journal of Intellectual Property, Information Technology, and E-commerce Law in English and in French. But we argue that this rethinking should apply to objects not just designated for restitution, but also those that remain in situ. And we highlight those who are already working in the area. So Auckland Museum has developed comprehensive cultural policies in tandem with the communities whose objects remain in their care. And there's a real opportunity here in the process to, what the report refers to as inverting the colonial hegemonic relationship around the treatment of cultural heritage. And this includes the heritage that remains in possession of the institution. And there's indigenization in Canada as well, who has been really active in this area and discussed methods of indigenizing collections management and digitization, especially around areas of data sovereignty, as well as local contexts, which is an initiative to support Native, First Nations, Aboriginal, and Indigenous communities in the management of their intellectual property and cultural heritage within the digital environment. And they do this through specifically designed labels around traditional knowledge and reuse. And finally, there's Whose Knowledge, which challenges dominant narratives of knowledge and recenters that of marginalized communities on the internet. So at the moment, digitization processes are currently proceeding under host communities' oversight, which precludes alternative conceptions about how heritage might be represented and presented to the public by the communities of origin. Because just as there are different interpretations or conceptions of what cultural heritage is, there are different interpretations of and conceptions of what digital cultural heritage is, as well as different types of engagement. So digital cannot be treated as an afterthought in this whole discussion. And even if the general consensus is to enable free and unfettered open access, we really need to critically examine the laws in place that will dictate how that proceeds. So that's the end of my presentation. And I think now Gabby is going to discuss the exercise.
Well, not only me. I'll throw up the exercise on the screen just briefly, but what's the best way to do this? So let's take a second because my screen is a silly shape. Okay, I need to stop sharing and reshare. No, actually, I can't share this. Can somebody else share the exercise on the screen, please? Sorry, my browser won't let me.
See if I can pull it up. How's this?
Yep, perfect.
Great. Okay.
So, so if you're watching this, you presumably know where to find the GitHub page for Sunoikisis's Digital Classics, and in particular the 2019 to 20 sessions and the Digital Cultural Heritage Session 7, which is the one we're talking about this time. So although you can't really read this on the screen in the GitHub video, you should be able to pull this up on your own machine. What we've given you is 4 themes. I say we, this is primarily Andrea. His work. 4 themes, race, legal possession, community voices, and gender. And we've given you a few examples of sites to look at under each theme. And what we want you to do, those of you in London area will have broken you up into groups to discuss this. But for everyone else, pick one. Pick one of these 4 themes and look at the sites that we've given you. Think about some of the questions in them, in particular some of the questions we've discussed in this session. A lot of the session, the questions that you just heard about from Andrea, the issues, colonial issues and others. Then look what other material you can find elsewhere online. How does that compare? Are any of these other resources give better or worse or different representation to these issues? You've already seen some of the examples that Andrea showed you of how the British Museum don't necessarily reflect the colonial issues of some of their holdings very well in their displays. We want you to think about those questions and be prepared to discuss those next week. But also concretely suggest some ways in which you could improve or supplement the resource that that you're looking at to better reflect some of these issues. And secondly, think about ways in which the relevant Wikipedia article on the resource or the issue in question might also be improved or supplemented to better reflect the issues that you think are important, that you think should be addressed relating to this issue. And I guess we don't want to give too much more leading guidance than that, because there's lots of different things that could be said about all of these, and we want to hear your ideas. But in particular, because this is a module on digital cultural heritage, think about ways in which the status of the resource as a digital resource. These are all, by virtue of the fact that we've given you web links to them, these are all web pages. How is the medium in which they're being communicated, or the audience to which they're being addressed, changing or potentially influencing the way that this is being communicated? Does anyone want to add anything to that?
I guess I would just say that the less you kind of have in terms of guidance, the better in these sort of kind of exercises, because it is also exercise in trying to unpack some of our own biases and examine and critically engage with the language and the presentation, which we don't give you as much to go on, can be a really rewarding exercise.
Great. I'll just stress again, as Gabby said, especially when you think about what could be done differently, to focus on the digital aspect of it. So, what could be done differently in the digital domain? And again, I don't want to give too many suggestions, because we're genuinely interested in what you come up with. And if you see a problem to start with, what are the problems that you see, and how they, how they become apparent, how they are somehow hidden, sometimes, more successfully than others, and so on. So, well,
can I add a secondary optional part to this exercise, which we considered, but we decided we hadn't focused enough on Wikipedia in these materials to make it a formal part of the exercise. But if as part of this work you find that one of the resources you've looked at is a Wikipedia page, and you can see ways in which it could be improved, you see where I'm going, don't you? Hit that edit button. And go ahead and improve it, right? Because even if you've never edited Wikipedia before, you should be able to figure out how to do that. And yeah, come along and tell us about what happened as a result of that. Did your improvement stay there? Did someone revert it? Did someone vandalize it? What happened? Did someone come along and say, no, you can't say that. This is a neutral resource. You're not allowed to mention colonialism, which. There are idiots who would say something like that in the world.
I mean, also, if you speak more than one language, and I know that is true for some of the students in the London class, maybe don't stop at the English version of Wikipedia. Mm-hmm. It may be, interesting and informative to see how, I don't know, the British and the Greek page talk about the Parthenon marbles, for example. I think that we have a question from Hannah. Thank you, Hannah. Can you all see the question, or shall I read it aloud?
Read it anyway.
I think this is mostly for Andrea. I was just wondering, I know fair use has been a recent legal battle, mostly with video, I think. Does this impact cultural heritage items in any way? So a little bit more about fair use, I guess. If you can say something about fair use in digital cultural heritage, I guess that's what Hannah's asking.
Sure. So kind of setting aside video, because fair use is a US specific type of copyright element. So when you're thinking about, some of the defenses or some of the rights to use some of work that might be in copyright, so the work itself is in copyright rather than in the public domain, fair use is usually something that within the US, depending on the context of the use, will allow you to engage with the work to a certain extent. But what's interesting about it is that it does impact cultural heritage items, because if the cultural heritage item is in copyright, then fair use will apply. Again, that only applies within the jurisdiction of the United States, but it is something that's starting to kind of trickle outwards, because it is one of the more expansive ways in which people are able to use in copyright material to affect how other people perceive copyright exceptions. Like in the United Kingdom, we have fair dealing, which is different, and in other countries as well. So it will only impact cultural heritage items that are in copyright rather than obviously in the public domain. But my area of focus isn't necessarily video. There may be other rights that impact video, so performers' rights in the United Kingdom, which is another kind of layer of consideration that you have to take into account. But yeah, I hope that answers your question.
Yeah, I had to deal in my previous job sometimes with movies copyright, and that was just incredibly complicated, because between the producer, the director, the distribution, there were sometimes like 30 people that were entitled to a little bit of the copyrights, so people just gave up.
In the digital world, there's another issue that often comes up, and this is particularly the case with video, but also sometimes with music and similar files, which is that even if you believe that, and I stress you believe, because this often has to be tested and proven before it can, there's not a hard and fast rule that says you can use X number of seconds of a work. If you believe that your particular use of a piece of video is covered by fair use or fair dealing or any other jurisdictional exemption from copyright, you incorporate that in your own video and you upload it to YouTube, the algorithms on YouTube will then recognize it as a copyright violation and you very often will get no appeal against that, and your work may be deleted, even though it hasn't broken any law, because the video hosting side are basically covering their asses and they don't want to take the chance on something, and that can be an added issue of difficulty. And so that can include something which might be completely out of copyright if you try to post something which is a piece of cultural heritage which is in the public domain, and it's recognized by an algorithm as something that already exists, as if you're plagiarizing something. They'll say, well, you haven't got the copyright holder's permission, you're not the copyright holder, we'll delete it, we'll block you from it.
So if is it okay for the speakers to stay 5 minutes longer so that we can maybe ask each other's questions? I would like to provoke Richard a little bit on the story that they told us about the National Gallery, the National Portrait Gallery. And I understand the position that Wikipedia decided to have, that they don't have to be, let's say, a damage, they don't have to threaten cultural institutions, because I see that there could be a friction there. But on the other hand, how rightful is an institution to claim exploitation of something that is in the public domain? And do you think that this will always be? Would you defend that position that Wikipedia took, or you think that it was more because it was the beginning and they were still building their public image? So what do you all think about that, besides the official position of Wikipedia/Wikimedia?
So, interesting question. With my Wikimedia UK hat on, I would like to keep organizations happy when it comes to Wikimedia. So even if we could, say, share their content, because in the public domain and digitizing it doesn't necessarily create any copyrights, I'd want to instead create a conversation with them, a dialogue, and try and win them over to releasing their content. Now, there's also a part of me which liked the activist nature of going in there and saying that these things are hundreds of years old. Thank you for digitizing them, but they're not yours to assert copyright over. Just taking a photograph of them doesn't create a new copyright. So part of me does quite like that it actually happened. And it was perhaps an important thing to do because at that stage, maybe institutions hadn't really seen that happen on a large scale. And they became aware that actually, yes, there are people out there who are going to say, well, this isn't your copyright. You can say that, but that's not necessarily how it will pan out. And so I was looking into this the other day, trying to refresh my memory what happened with it. And the results seem a little bit muddy. So the Wikimedia Foundation paid for the legal representation of the person who uploaded the images. Okay. The foundation weren't ultimately responsible for what's happening. It was happening on their platform, but because they're not actually going out and rewriting Wikipedia pages themselves, the staff, then they don't have the responsibility to go in and fix stuff when it goes wrong. But they're able to support the person who was having to deal with the situation, which I think morally they had to do. It was the right thing. Because this person was acting in good faith. They saw these images available online and thought, well, we can share these through Wikimedia, reach a whole new audience, and they can be, a global audience can benefit from them. And it seems that the issue kind of just petered out without necessarily concrete resolution one way or another. So in theory, people could go out and do that again. I'm not sure what the results would be, but it'd probably be interesting in a way which causes Wikimedia UK a few headaches, given that we don't want to annoy institutions if we can find a way to work with them instead. Yeah, it was an interesting situation to to look in on. And yeah, well, I was quite glad the person did it. I'm not sure I would have done it myself.
Okay, thank you. Do you want to comment on that, Andrea?
Yeah.
I knew that.
So juicy. No, this is, it's actually like the perfect example of kind of just how this continues to play out. It's a really bad look for institutions to sue a user for, taking something that appears to be in the public domain and making it available online, to further cultural appreciation and the pursuit of knowledge. The question there, though, is also that, there's actually kind of a benefit to avoiding taking someone to court, because when you take someone to court and you get a ruling that's not in your favor, it then will apply not only to you, but to everyone in the industry who's doing that exact same thing. So there's a bit of a legal strategy to, first sending a cease and desist, which was the first thing that they did. But there were some other legal questions that weren't answered in terms of what the user did. His name was Derek Coetzee. And that had to do with the way that he obtained the images, because at the time, the National Portrait Gallery used a tiling system to take all of the images and make them available really high resolution, but in a way that people weren't going to be able to download them and then kind of circumvent their right to be able to benefit economically through them by charging copyright. But Coetzee wrote an algorithm that circumvented the technical measure, downloaded each of the tiled images, reconstructed them, and then uploaded them to Wikimedia. So in addition to the question around copyright, there was also the question of, did he violate the terms and conditions by, using the website in this way? And there were some other, really complicated other legal questions that just didn't get answered because, nothing came to court. So they kind of, as Richard said, it petered out. They kind of walked away from each other. And, even after that, I think there's a really great presentation that is on the Open Glam, I think 2010 wiki page that is from Tom Morgan, who was the head of Rights and Reproductions at the time. He calls it a bad first date in terms of the National Portrait Gallery and Wikimedia. And there's some really interesting comments if you listen to that presentation at the end. Harriet Bridgman, who is the owner of Bridgman Images, makes some comments as well. So it's really interesting in terms of, you hear from the Wikipedia community, you hear from the institution, and then you also hear from someone who's heavily invested in maintaining the status quo for their own business purposes. But we do have a case last year in Germany. It's the Reiss-Engelhorn Museum, and what happened was the Reiss-Engelhorn Museum had published a catalog, and a user had taken the catalog and scanned in some of the images from it and made those available on Wikimedia. And then he also had visited the Reiss-Engelhorn Museum himself and taken photographs of some of the works and made those images available as well. And when the Reiss-Engelhorn Museum saw that this had been done on Wikimedia, they not only sued Wikimedia, but they also sued the user, and then they sued everyone who had used the images internationally. And actually, the case went all the way up to the Supreme Court in Germany. And Germany has a bit of like a special exception in copyright law where, of course, in order to get a full copyright according to how it is in the EU in harmonized terms, it has to meet the author's intellectual creation threshold. But they have like a sub protection, which is a related right for photographs that aren't as original as, what an original photograph would be. And those are photographs that require personal or minimum personal intellectual input. And so this was actually what the outcome of the court said. They said the images are not original, but they do attract this lower threshold of protection. And the protection is almost just like copyright. Instead of 70 years, it's 50 years from the date of publication. But then again, we have the new Article 14 from the Digital Single Market Directive that's coming out that's supposed to eliminate the ability to be able to take photographic reproductions and claim copyright and this sort of thing. I'm a bit skeptical as to whether or not that's going to happen. So this is just such a hot, juicy area, not stressed enough. And when these kind of situations play out, like there's not many of them. So we're hungry to see how it happens because, yeah, for the most part, parties avoid the court because they don't want to generate, the bad will, the press.
To set a precedent.
Yeah, and set a precedent that would be unfavorable.
It is a very, very juicy area. And also, I think it also involves, I mean, what is the mission of a museum? I mean, it's to profit from the things that they have, or is to promote the knowledge of those work of arts. And I totally understand the smaller institutions, and sometimes the bigger one as well, are always, underfunded, and they always, look for, satellite ways of making money. I completely understand that. But on the other hand, it feels like the number one mission of a museum should be the biggest number of people, looking at the thing. And if that is your mission, having your images on Wikipedia is, you can't get much better than that.
The trustee of the museum, I think, would respond, or some museums would respond, that the first duty of the trustee of the museum is to make sure the museum stays afloat financially. It can't do any of those other things if it goes bust. That doesn't. I don't believe that counteracts your argument, because there are other ways that they can monetize this. That the higher footprint they'll get, the higher attention they'll get from these materials being openly available, especially in something as massive as Wikipedia, will I think, but people are very nervous about losing control.
No. I mean, I totally feel the tension, but yeah, I also think that there is a little bit of narrow-mindedness sometimes, and a will to maintain the status quo that is very unbalanced. So.
And within organizations, you'll often see that some parts are really keen on getting stuff shared. So especially the curators, they want the stuff out there so that people can see it. Ideally in a way which they have some control over the framing. So, curators, they put in a lot of effort into how it's presented in the first place. And you might find that the commercial side of the organization, people dealing with the image rights, and so on, are the ones who are sitting back a bit and saying, is this good for us right now, or are we potentially losing money as a result? So even with an organization, even within a fairly small one, you can have those differences of opinion. And that can, ends up with a stalemate, which defaults to then not share it just because it's easier, quite frankly.
Yeah, I mean, I think you all raised a lot of very interesting points, and I would like to go through all of them, but I'm afraid I can't. I guess that one last that I would like to mention is what you were saying about digitization being obviously not a neutral process, and also the fact that all, let's say, stolen, because they are stolen artifacts, in particular the African ones that get digitized in Europe, in your case study in France. Not only, the people in Africa are excluded from, taking decisions about the digitization, but they're also excluded by, a market, by, digitization specialists in Africa don't get to work on their own culture heritage. Is digital experts, is basically us, is digital experts in Europe that get paid to digitize indigenous artifacts, which is, another way in which, even when we say we're digitizing so we can share, so we can, digital repatriate, still it's European institutions that are making money out of those artifacts, and that is, kind of sad. And that was my last comment. I think I should shut up now because it's already 35 past. So unless any of the speakers has a final comment or remark, I would just thank you all very much. And for the people that are still watching, I'll see you all next week.
Next week we'll be talking about GIS and geovisualization.
Yes.
Thank you.
Thank you.
Thanks for inviting us all.
Cheers, bye.